Okay. Mr. Chairman and members of the committee, thank you so much for holding this wonderful meeting, this great room. This is terrific. When I was here before several years ago, we were downstairs in a much smaller room. This is terrific. Thank you for the opportunity. I am an attorney, been in practice since 1976, so that's getting close to 50 years. I've argued 2 cases, constitutional cases, in the Supreme Court of the United States, and I've litigated the Article 5 issue in the past. In the late 1970s, when Congress tried to change the deadline for the ratification of the Equal Rights Amendment, going from 7 years to 10.5 years, I represented several legislators from the state of Washington in a case that got consolidated together with a similar case in Idaho and Arizona, and worked together, and the net finding of that case was you can't change the rules in the middle of the stream. And that was the holding of the federal district court. It went to the Supreme Court of the United States, and the Supreme Court made a summary ruling because the second deadline passed, and they held basically that the ERA had expired, and so that the prior decision stands as a persuasive but not binding precedent. But it's one of the more important precedents is Article 5, and so I'm one of the rare lawyers in the country that's actually litigated and researched on Article 5. In addition, and this is germane to the Runaway Convention, I've published an article in the Harvard Journal of Law and Public Policy to definitively answer kind of the baseline question of whether or not the original Constitutional Convention was a runaway. I mean, the theory goes, well, they were only supposed to amend the Articles of Confederation, and instead they wrote a whole new document. That's the genesis of a lot of the arguments that raised about the Runaway Convention. It's just simply, historically, not true. As we all probably remember from our history, the Annapolis Convention was held previous to that. They'd been given, the delegates had been given responsibility by their various states, authority by their states, to discuss problems with commerce. We needed to have a different mechanism of regulating commerce. The delegates got together and said, we don't have enough authority to solve the real problems, and so they went back to their states and asked for more authority, and the authority they asked for was to render the federal Constitution adequate for the exigencies of the Union. Several states started passing resolutions calling for a convention in May of 1787 in Philadelphia for that purpose, to render the federal Constitution adequate for the exigencies of the Union. 6 states called for that convention, named their delegates, gave their delegates their various voting instructions, and then at that point the Articles of Confederation, Congress passed the resolution that has the language, only amend the Articles of Confederation. That's where it comes from. It's from that congressional resolution. Now, when Congress, the Articles of Confederation Congress, wanted to communicate to the states and ask the states to do something, they had a process of passing 2 resolutions, the substantive resolution, and then they voted and approved official letter of communication. Congress never passed a resolution of communication of the resolution because it wasn't intended as a request for the states. It was like a congressional resolution today endorsing National Pickle Week or something. It was expressing the beliefs of Congress about it, but it was not a binding document. We should all know that under the Articles of Confederation, the Articles of Confederation Congress had no residual or implied powers to do anything. They had no power to call a convention or anything else. And so after they gave their resolution, the rest of the states continued, and New Hampshire was one of them, continued, and New Hampshire told its delegates to render the federal Constitution adequate for the exigencies of the Union. And that's what they did. And this article goes into great detail to prove that the delegates officially obeyed their instructions, not only on subject matter, but on voting process as well. The delegates can be held to be faithful. New York, for example, said that all 3 delegates from their state, that included Alexander Hamilton and Yates, one another man's name's escaping me at the moment, the 3 of them all had to be present in voting for New York to cast its one state, one vote. And 2 of them got mad at the way things were going, they left. New York never voted again. So Alexander Hamilton never tried to cast the vote because that would be violating the standards that the state of New York set upon its delegates. The rules that states give their delegates have to be followed, and the historical precedent is absolutely without exception. So, and there's a similar answer, it takes a long time to explain, as to why the ratification process was proper as well. The short answer is the 1787 Constitutional Convention proposed 2 documents. The Constitution was one, and a methodology of ratification was a second. The Congress, under Articles of Confederation, unanimously approved the methodology only, didn't vote on the Constitution, sent it to the state legislatures. All 13 state legislatures approved the new ratification process, which is the way it had to be done under the Articles of Confederation. Congress and all 13 states had to approve any change of process. That's what happened. And then it was sent to the state ratification conventions. We all know that it ultimately got ratified. So the whole runaway convention mess is anti-historical, and frankly, it's defamatory of the Constitution of the United States. Because if it was a runaway convention, then the Constitution of the United States was illegally adopted. And I don't know why anybody would call themselves a constitutionalist. I don't know why anybody would swear an oath to uphold and defend the Constitution of the United States and contend it was illegally adopted. You are not a constitutionalist if you think it was illegally adopted. You are anti-constitutionalist by definition. And so the people that are spreading these rumors about a runaway convention do not know the law, do not know the history, and they're putting forth propaganda of people who have been enemies of the Constitution for years, and it's simply inappropriate. Now, why do we need this convention at this particular time? The sponsor gave you good reason, but I'll just say this. The reason that George Mason and others said that we need to give the states the authority to amend the Constitution is the federal government's going to abuse its power. Now, think if I have 10 kids, 29 grandkids, you take over America your way, I'll take over America my way. Think of what would happen if I never disciplined my 10 children. They would grow up to be pretty rowdy and inappropriate. You couldn't trust what they were doing. Now, for over 200 years now, the parent, who are the states, have never used Article 5 to discipline the runaway of federal power. And this convention needs to be called to show the Congress, show the federal government, there are limits here. And we have the authority to change your mind. We have the authority to change your pattern of behavior. And the subject matters that we've given are limiting federal power. And for example, my personal favorite is to impose a single subject rule on Congress, to not let them pass the $1.7 trillion package bills where they throw everything under the sun into it. And that would not happen if you simply passed a single subject rule. What's going to come out of this convention like this is going to be something short, concise, and commonsensical like that. There might be 2 or 3 other things, but what we're doing in this stage of the process is setting the agenda for discussion. The agenda for discussion is fiscal restraints, term limits, not just on Congress, but on all federal officials, and other limitations on federal power. It's safe. We've litigated. We've done the historical research. If you have any questions, the article that I've given, Mr. Chairman, I'll give you my hard copy. All the documents have been posted on your website or your link, so you all have access to it. And I would be glad to answer any questions that you have. Thank you for this time, Mr. Chairman.
Thank you, Mr. Farris. Questions for Mr. Farris? Representative Massimilla.
Thank you, Mr. Chairman, and thank you for taking my question. Could you explain to the people at home the difference between an Article 5 convention, a constitutional convention, and a convention of states?
Okay. 2 of them are synonymous. An Article 5 convention and a convention of the states are the same thing. 2 names for exactly the same thing. A constitutional convention is what you would do if you were trying to rewrite the document entirely. And in order to do that, we would basically have to do the revolutionary power under the Articles of the Declaration of Independence, where it says people get upset with the government, they have the authority to redo it. That's what you'd have to do to have a constitutional convention. To an amendments convention, there's an amendments convention in session right now. It's called Congress. And every day they're in session, they can propose amendments to the Constitution of the United States. And so this would be a convention where the states pick who's there, and the states get to control the agenda, not Congress. So the amendments are going to come from one place, and ultimately, for the resolution that we've proposed, it answers 2 questions. who decides how much power the federal government should have? Should Congress decide how much power the federal government should have, or should the states, for this convention process, decide? And I think it's high time that the states say, we're going to do it ourselves. So our Article 5 convention states exactly the same thing. The founders called it a convention of the states, and that's when I basically wrote the text that you've got before you. When writing that, that's why we called it that, because of the historical use by the founders.
Thank you.
Ms. Farris, if this proposed convention were to occur, who would be the convener or the convening officer, and where would it be held? Who would determine where it would be held?
Well, when there are 34 states that call for a convention for the same purpose, now there are hundreds, probably about 500 current valid resolutions that call for a convention of the states on a lot of different topics. And they don't coalesce. And so the reason you can't have a runaway, you can't coalesce to call a convention, you can't change the subject matter at the convention either. But the Congress calls a convention, they would name the time, they would name at least the initial place that it meets. The convention itself, at that point in time, once they convene, could adjourn to another location. And so if, for example, they decide to put it in Washington, D.C., I don't think that's a particularly good idea. I think that there'd be a lot of momentum for moving to a different location outside the Beltway. And so, but the states themselves would decide the rules. There are a lot of states that are looking at passing a recommended rules package. And if enough states commit themselves to a particular rules package beforehand, it's like the Delegate Limitation Acts that a number of states are passing. And we are working on a complete rules package. Our organization has sponsored the Article 5 compendium. That has all the law. If you want a full compendium of all the law on the subject, we have it available for you. And we're working on a package of rules to make it happen. But in the meantime, probably the Mason's rules of legislative practice that would be in control.
Thank you. Other questions? Representative Carey.
I just want a clarification for the record. Who are you representing?
I represent the Convention of States.
Convention of States.
Precisely, Convention of States Action is the full name of the organization. Yeah.
And once again, you said this earlier, for those that are watching on the intranet or will watch later, you just gave us your organization. Is there a website, or you repeat where you said that information can be found?
The organization is Convention of States, cosaction.org, is that right? Or conventionofstates.org. Thank you. I founded it, but I've gone for 6 years. I was the president, CEO of Alliance Defending Freedom for the last 6 years, the largest conservative legal organization in the world. And so, but I've retired from being CEO. I get to actually be a lawyer again.